The left lane is less bumpy, just like a living man should be. I've been traveling this way for 28 years before YouTube was even on TV. They call me a living man, but mostly just Eric. I am not for hire, taking no money for my rides, I just travel, and when I do, got my moped in the fast lane, a beautiful machine. Going a cool 25, backing up for 50 cc's, living the American dream. Dream, dream, dream. Got the supremacy clause, Article 6. The police will see when they face 15 years for harassing me. They call me Eric, but that's a corporate name. I'm a living man, this ain't no simple game. My birth certificate's a fraud, illegal fiction, a lie. Your state laws don't apply here under federal statute and code. I learned it all on YouTube, then confirmed the law book. The pages are not with me, but the proof is in the photo I took. Got my moped in the fast lane, a beautiful machine. Going 225, backing up for 50 cc's, living the American dream. Dream, dream. Got the supremacy clause, Article 6. The police will see when they face 15 years for harassing me. The police will see when they face 15 years for harassing me. Moped, fast lane, living man, unlawful, perjury, don't need a license, just a ride, scumbag lawyers. You can call me Eric.
The Thurston County Correctional Facility. What's your name up there?
Alicia Martini.
And then I don't see Ms. Millar up there. Ms. Moore, are you covering that one from here?
Your Honor, Ms. Martini is pro se.
You'll never believe it, but Miss Martini got a DUI. Then the Martini made me think Eric Martin. So, you know, there you go. There's our intro.
Give me just a minute, ma'am.
Jason St. George. This goes a while. It's a good hearing. Jason St. George, bottom right, enjoys the whole thing. He's like a Law Talk with Mike viewer. He just enjoys the hell out of this. Ms. Martini is currently top left.
Okay. So it's on the case ending in 853. Retrial.
Your Honor, on 6/6 of this year.
Wait, ma'am. Just give me a minute, please, ma'am. So on the new case, Ms. Moore, 25 DV 1023, she's here on a warrant return on that case. She's held on bail on the other case. This is the arraignment on the protection order case. But it looks like You've already set confirmation and trial dates without her being arraigned? How did that happen?
I have no information, Your Honor. Ms. Martini has declined counsel. She wishes to represent herself.
Okay, so hang on just a minute. Yeah. No trial dates are set on that, on the protection order case. The trial dates are on the trial dates are on the DWLS and the third and operated motor vehicle with ignition interlock. There's no trial date set on the DV case. Okay, so ma'am, your name is Arlicia Martini?
Yes, sir.
And then you're here on a couple of things. You have that are unrelated. You have some driving offense, driving with license suspended in the third degree, as well as operating a motor vehicle with ignition interlock, without an ignition interlock when it's previously ordered. And then
My original
you do have
DUI
trial
was
dates.
thrown out.
Just let me, ma'am, just let me finish. I'm just telling you what your charges are now. I don't know about prior charges. That's a charge. You may have a defense to it. I'm just saying that's what you're charged with right now. You're also charged with one count of violation of a protection order. And then you haven't been arraigned on that. We're gonna do that at some point today. So on the violation of a no contact order, and again, these are just allegations, that's a gross misdemeanor. That carries with it a maximum of 364 days in jail and a $5,000 fine. So anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. You have the right to a trial by jury in the county where the crime is alleged to have been committed. You have the right to hear and question witnesses called by the prosecution. You also have the right to call witnesses in your own behalf, and I can require the attendance of your witnesses through the use of subpoena. You're presumed to be not guilty of the crime charge. You cannot be found guilty unless the prosecution proves the elements of the crime beyond a reasonable doubt at trial, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify on your own behalf if you choose to do so. And finally, if you take this matter to trial and lose or are convicted, you would have the right to appeal your court. Do you understand all those rights?
Yes, Your Honor.
Okay. I want to go back to that first right, and that's the right to an attorney. That's an important, and if you can't afford one, as I said, I can appoint one to represent you. And I'm fully prepared to appoint an attorney to represent you in this case that you're in front of me here right now. And most people, pretty much everyone else, when they get the opportunity to have an attorney appointed to represent them, they jump at that chance. But I'm told that you're not as inclined to take advantage of that offer.
Yeah, I'm a sovereign citizen, Your Honor.
Okay. You sovereign citizens can take advantage of an attorney as well.
It's okay, I'm pro se.
Okay. Have you ever, give me a minute. Why is this jabs taking so long? Listen, that's one thing. I don't know. I have to keep doing this. So, ma'am, you have you ever represented yourself before?
Yes.
Okay. Have you ever gone through jury trial?
No. I
Have you
never
ever
had
been
to.
law? Okay. Have you ever been to law school?
Nope, never had to. They got dropped.
And you're not a lawyer.
Nope.
Okay.
I'm a
And
sovereign
so,
citizen. My
you
charges got
understand-
dropped.
Okay, but I'm not sure about these cases, but you
They were
understand the
already
prosecuting.
NFC'd.
Okay,
These charges
so
were
ma'am-
already NFC'd last time I was here in jail.
Okay, so ma'am, you understand the prosecutor in these cases are lawyers. They've been to law school. They understand the rules of evidence, rules of criminal procedures, things you may not be trained on. So you're operating at a pretty serious disadvantage. Do you understand that?
Yes, Your Honor.
And knowing all that, you still wish to represent yourself at this time?
Of course.
Okay. Which case? Is that her case? Okay. Oh, I see. That's it. Right. There's 853. Yeah, the pre-trial, and then there's 20V to it. Okay, and then the 1017. Is that set for trial? Is she being held on that? Oh, I see. Yeah, that's the only. Was that the only one she's being held on? So you actually have 3 cases. One was just added. That's why there was a little bit of a confusion. You're charged with, on the case 25 DV 1017. This computer, man. She's being held on that. Okay, bail's set on that. And then it looks like, I'm not sure I agree with that. Yeah, the new one has $5,000 warrant, but I don't see any bail set on the old one. Keep refreshing. Okay, so ma'am, you have a court date set on the DWLS and the operation of motor vehicle without an ignition interlock. You have trial confirmation on January 7th. You have trials on January 12th and 13th on the assault in the 4th degree. On the new charge, which is protection order violation, a plea of not guilty will be entered. This matter will get set for a pre-trial. We can do that also on, and you're not being held on this is a warrant return on the new charge, the protection order violation. There's $5,000 bond on that. I don't bail on that, or warrants. I'm going to hear from the state on conditions of release on that, and then I'll hear from, I'll come back to you, ma'am.
Okay.
Mr. Libby?
Your Honor, no objection to leaving the conditions that were previously imposed as is. That's the $5,000 bail that was set on December 1st for this new matter, 1023, as well as the previous conditions that were imposed at the prelim all the way back in October 27th.
Which are no criminal law violations, comply with the no contact order?
Yes, Your Honor. Sorry. Yes.
Okay, so on the case ending in 1017, there's going to be no changes in conditions of release on the case, and then your next court date is January 7th, I think. On the case with the operating motor vehicle without an ignition interlock and the driving with license suspended in the 3rd, that'll no change in those conditions also. There'll be $1,000 bail set in that case. In the new case where we are setting where you're getting arraigned on, which is case ending in 1023. I'm not going to hold you on that case either. All prior conditions remain, which are don't have any criminal law violations, don't possess a firearm or other deadly weapon, comply with any existing no contact order. We'll set a pre-trial. We'll do it earlier than that and back these up on the other one. We'll set a pre-trial on Wednesday, December 17th. We'll set it right on the 1:30 calendar. Or actually, no, we'll set it earlier than that in case she makes bail. And that's only $1,000 at 10 a.m. And that'll be it for today here. And then you can be taken back. Do you understand all that, ma'am? Yes.
Can I please fight for my own bail?
Can you
That's
what?
my right. Fight for a PR. That's my right.
That it is. And you that was.
And you said you were going to hear from me and you didn't.
Okay. I can hear from you now, because I'm not holding you on the new charge. They're only being charged on bail on one case. And that was the case that was decided by Commissioner Wool, a day or two ago. So if you're asking me to reconsider or redo what he did, yes, you can do that.
Yes, Your
Go
Honor,
ahead.
please. Okay, so I've been held for a substantial amount of jail time on both of these charges now. They're both misdemeanors. Neither one is violent. The driving charge, like I said, I'm a sovereign citizen, so I have the right to travel. And also on 6/6/2025, that charge was vacated due to speedy trial rights violated, because from 2019 to 2020, I never had a court date set because of COVID. So they vacated that charge on 6/6 of this year. I got a status case report from the Thurston County Clerk on 6/6 stating that that case was terminated.
Throw this thing out the window. Mr. Libby, what's this? Again, I do that from 2020. Ma'am, I don't see that case was dismissed. I'm looking through the docket now. Looks like you had an attorney for a while on this case.
Yeah, on 6/6 of this year, there was a case status report from the Thurston County Clerk stating that it was terminated or vacated. Terminated. Case terminated due to speedy trial rights, because if you notice from 2019 to somewhere late in 2020, there was never a court date set because of COVID.
Okay, so hang on just a minute, ma'am. Mr. Libby, you wanted to say something?
So I'm seeing there was a hearing on
6/6,
June
yes.
6/6. I was present for that. I believe the state asked for a motion to continue. Mr. Pazderka objected. Trial was reset, or the hearings were reset 1 week, and we entered an excluded period.
Right. And then she didn't appear for trial. And a warrant was issued on 6/23.
Yes, I'm seeing that as well, yes.
So, ma'am, I'm not reading the docket the same way that you are.
Okay, maybe the date that I have is wrong, but it said case terminated. I got a case status report sometime in June, I believe.
Okay, and what my reading of the docket says, you were not here for confirmation on June 6th. The trial was going to be set for June 23rd. You were supposed to be there on June 23rd. You did not appear, and then a warrant was issued at that time. And I don't see anything. One thing that may have been canceled was your trial date was canceled once you missed your court date for a warrant.
No, it literally
But the
said
was
case
never met.
terminated.
Please don't, okay. I don't see that. And I don't see that in the docket that I'm looking at.
Your Honor.
And so,
No, I'm
If I
asking
may.
to be released so I can get that information for you.
okay, go ahead.
Nothing, Your Honor. I'm just trying to clarify stuff.
We'll go ahead if you can. That would be great.
There doesn't, Mr.
If
Chair,
there's
point
ever a
out,
case in need of clarification, this would be it.
there does appear to be a 2017 Superior Court matter that was vacated. I believe it was a Blake case.
I can help, Your Honor.
Oh, I see.
Here. Case 17, TAC 1, TAC 04338, TAC 0. I wonder if Miss Martini is maybe getting that case mixed up. That was a Blake
No,
vacation.
no, I'm not.
Okay.
It happened.
So, ma'am,
It was case terminated, not vacated. Yes, I had a case vacated as well from the last time I was in prison, but this case was terminated. I'm just asking that I please be PR'd. These are not violent crimes. The victim was not the reporting party of the no contact order violation. I don't have any way to post bail or any way to even contact anybody right now, as the victim was my only person that I had in life, pretty much.
right,
So
ma'am.
I'm just asking that I be please PR'd.
What I'm going to do here for today, ma'am, I'm going to set the protection order. The new protection order will be a pretrial on 10 a.m. on December 17th, and then on the what I will do is this, ma'am. I'll set this back on the calendar for only being held in bail on one case, and that's the DWLS third and the ignition interlock. And it's probably been around for quite some time, but now that you've given notice to the state of your wish to have bail reviewed, we'll set this over 24 hours tomorrow, and then we can check in to see whether this thing has actually been vacated or dismissed or what have you. And then we can reconvene tomorrow for a bail hearing on the DWLS in the third case. And then the other can be backed up to it. All right? Now,
Your Honor, one more thing. So is the defendant not being held on that new charge, that violation of protection order? There was bail imposed. Is that being?
No, that was a warrant was issued in the amount of $5,000. She was picked up on the warrant. Now the warrant's been served. So now we go forward. Then I make a decision as to whether set bail or something like that. That's my reading of the docket.
My reading of the docket, Your Honor, is that there was a warrant FTA at December 1st, and Commissioner Wool imposed $5,000 bail on that new protection order violation.
Give me a minute. And that's the 1023 case, right?
Yes.
Oh, you did see, yeah, I did see, I see that now. I didn't hear Rayner on that day. You know why it wasn't arraigned on that date?
I don't have any other notes, Your Honor, other than bail was
Why
imposed
would
and
they-
arraignment was just set for today. I don't know why it was set for today.
I don't either. And that was the first, that was Monday?
Yes.
We'll just put all these on tomorrow. Do all these on tomorrow for conditions of release and set all that. We've taken way too much time on this right now. So ma'am, you could have conditions of release addressed on all these cases tomorrow at 1:30.
Okay.
And between now and then, I'd really think about your decision not to take advantage of an attorney. I think you're doing yourself a real disservice if you want my frank opinion.
I'm a sovereign citizen, Your Honor. I trust in my own opinion.
I heard you. And I
didn't
can't save
hear
you
me.
from yourself, but I'm just saying that, I'm just saying. So we'll all reconvene tomorrow to address conditions of release on all of these, so we can get all this sorted out. And you can be taken back, and yeah, the 5,000 will remain. And so at Nisqually, what's your name?
Aaron Morgan.
Say that again, please.
Aaron Morgan.
And we are ready on that matter. It is an arraignment. We will waive formal.
I had to let this run a little bit because I didn't know how long it would take her to clue in that she needs to leave. There's some editing still, but it takes a minute.
reading, ask the court to enter a plea of not guilty. We'll stipulate to probable cause. I also spoke to him about his financial situation. I do believe that he qualifies to have a public defender appointed.
So Mr. Morgan, you're now charged with 1 count of theft. That's a gross misdemeanor. And Ms. Martini, you can be taken back. You're free to go back.
Yes.
The plea of not guilty will be entered. This matter will get set for future hearing. I will appoint the Pacific Point Law Group to represent you. I'll hear from the City of Lacey, and then following that, I'll hear from Ms. Alts.
In Your Honor, in this matter, the city is.
All right. Finally, she busts out. That was a mellow one. It took a while to develop, but I really enjoyed Judge, I was traveling. No, Judge, I'm a sovereign citizen, so I have a right to travel. Oh, okay. Well, then everything is just dismissed. Don't worry about it.
Holy wow. That's messed up.
Okay, there's more in this call. We've got a little update from a guy I just did a couple days ago that I thought I saw yesterday, which I think I did now. But anyway, he's good. He's cray-cray.
Fine with Mr. Morgan being released on his own recognizance. We would ask for.
Yes, you, sir. What's your name?
Are you speaking to me, Your Honor?
I was, and still am.
My name is William Gordon Keith.
Yes, Your Honor, this is my client. He's numbers 7 and 8 on the calendar.
This guy is straight loon. He says all the same crap again, but it's fun.
What's happening today with this, Ms. Clark?
Yes, Your Honor. I have submitted a 1077 request to the court. Upon review, I noticed that the court date listed was for the 2nd of December. That was my initial 1077 request I submitted. If the court would like me to have one with the updated next court date of trial confirmation of December 26th, I can definitely do that. I can coordinate with the prosecuting attorney.
At least it wasn't 6-7.
I've crossed that out and just wrote
Your
in.
Honor, if I may, I have an objection to that, sir.
Okay, that's fair.
I have an objection to that, sir. I requested to move on with my pretrial date, and I objected to the 1077, which was previously denied, and they just switched attorneys, and I actually fired her previously and her firm, and I filed a conflict of interest. I had to file my motion verbally with the court because I was not granted access to paperwork, and all parties were present, Your Honor, on the record. Your Honor was present. The district attorney was present. The attorney's office and her firm was present in lieu of Miss Jasmine Clark was present, and Miss Jasmine Clark is currently present. Currently, we are having a conflict of interest. She's not moving on with me in the pattern that I wish to be. They keep just wasting my time and the court's time. This has been cleared several times in several places, and I would like to move on with a change of plea and just plead guilty and start my time so I can get back to my children, my home, and my job. There's nothing wrong with my cognitive thought process. There's nothing wrong with my ability to express myself.
This guy is so repetitive. I had to check. This was from a call from just now. I mean, this just happened maybe, I don't know, half hour ago. And but he's a broken record, so it sounds exactly like the last time I had him on. It's kind of fun.
Can you stop for a minute?
Yes, sir.
Okay, hang on just a minute.
I'm sure.
So, Mr. Keith, looks like you're here on a DUI and then hit and run attended and DWLS in the third. You understand those charges? Do you remember those charges?
Yes, sir, I do.
And you're telling me that you now wish to plead guilty to those charges?
Yes, sir, I do. I've had time to think about it. I've been sitting here, and I don't want to be dishonest or waste the court's time.
Well, you're not wasting my time. Don't worry about wasting my time. This is my job. I'd be here anyway, so you don't need to worry about that. But what I will say is this, Ms. Clark.
Yes, Your Honor.
He seems coherent to me. He seems like he wants to go forward. So I'm going to hold off on signing this for right now. And we can just set this over to tomorrow. If you can meet with him tomorrow, and if you can meet with him and prepare plea forms and go forward.
I give Meyer credit here. Yeah, he's not fully there, but he's probably competent to stand trial. It's a very low standard. And the guy's ready to plead guilty on everything. And he is guilty. And we're not there yet, but he's like, well, let's set it over tomorrow and see if we can close the damn case down. It's a very intelligent play. And it takes an ounce of stones because you can be criticized for trying to do it even though he's not fully there. He's not fully there, but he's competent to stand trial. So it's best to resolve it.
And we can take care of all this tomorrow and be done with it.
Your Honor, if I may weigh in as a friend of the court.
Everybody's my friend today. Go ahead.
I know. So, Your Honor, I appeared with Mr. Keith on Tuesday and also I shared the concerns that Ms. Clark has. There were a number of things he said to the court at that time that were contradictory and indicated he may not actually understand the nature of sort of what's going on, may not have been able to keep track of time passing and events in what order they've happened. He indicated to the court that he had not been arraigned on these charges at that time.
Well, if our experience today shows us anything, that people can get confused over court dates and what happens and when. And I am going to give you a chance. We're just going to I'm not signing this now.
This is low-key ballsy. I didn't think he had it in him. It's very minor, but he's just like, come on, close enough. Talk to him. He's ready to plead. Let's do this thing tomorrow. I like it.
Without prejudice, with people to set this over for 24 hours. If you can get up there and talk to him, and we can get in a place where the case can be resolved, then great. If not, then we can come and I can sign this over his objection. But I mean, shoot, I spent half the calendar up here confused about what did what and all of that. So, Ms. Clark, you can go up, see if you can talk to him, and then Mr.
I have no idea where my pants are. I mean, if we're all just giving confessions here.
Keith, I'll tell you, these attorneys, Ms. Moore, who's here with me in court, Ms. Clark, they know what they're doing here. And, they've, and you think, well, you've had a lot of experience in the criminal justice system, so you know what's going on. But you know what? They've had more. Because they're here every day and this is their job. And so they, I would encourage you to give them a listen as to what they're telling you. And
I did take the time
I understand
to listen
under
to
the stress of the moment, people get confused and all that sort of stuff. But Ms. Clark will just, again, see if you can talk to him either this afternoon or tomorrow, and then see where we're at here tomorrow at 1:30.
Yes, sir.
And then go from there.
If I may,
All right,
Your Honor, one more thing. I would like to take time to thank you for your time. I understand it's your job. I understand you're going to be there anyways. But the fact of the matter is there's a lot of important things that are going on. There's a lot of things that you need to address. And I don't want to be clogging up the
I don't know that it's going to be me tomorrow, to tell you the truth. But anyway, it'll be on for tomorrow. And I'll let the judge know, whoever it is tomorrow, and have a long conversation about a lot of the calendar tomorrow with that judge. But I do know it is not me. So we'll see tomorrow where we're at, and then give a good listen to Ms. Clark. And
yes,
then,
sir. I just don't want them being prejudiced against what I would like to do. I would like them to represent me accurately and move on with my wishes. And because I don't agree with them and I want to move on and I want to plead guilty, they're thinking that there's something wrong with my ability to think rationally and my cognitive thought process.
I wouldn't presume to know what they're thinking. I will tell you that. But one thing I will assure you, whatever they're thinking, it's in your best interest. And, I'm asking you, them to listen to you, but you need to listen to them too, and maybe give them some deference. And anyway, we'll just reconvene tomorrow and see where we're at. But that's it for today.
Yes, sir. I appreciate you. Thank you for your time.
You're welcome.
Thank you, Your Honor. This completes my matters.
All right. And Mr. Keith, you can be taken back.
Thank you, Your Honor. I was asked to wait patiently. It said that there would be a minute, so I'm just trying to be good and not cause problems or disruption.
I'd want a few up there. I think you'd be all right. What was the court date I sent that Giroff case in? That was next. That was
1:10 at 9 o'clock.
12:10 at 9 a.m.
No, January 10th.
All right. Let's get, you guys were right on this.
All right. I have no idea what's going on here. This is Alyssa's fault. It happened during the stream, and Brecken put it together for me like a hero. Let's see what we're dealing with.
Saying you're all on one device. Can you unmute position 2, Newsom and Johnson?
Yes, I can hear you. I don't want her to speak. Yes, I can hear you.
Well, wait. Well, hold on. Let's not do it like that. Okay.
I mean, it looks good. It looks strong. So just just the number of people crammed into the frame. It's got to be awful. It's going to be terrible.
Just don't do that. Let's not start it like that. All right.
Well,
so just wait, because everybody wants to be heard and wants something. So I just want to make sure I can address and know who I'm speaking to. So you are in the back. Since we're all
Destiny Johnson.
You're Destiny Johnson. You're the person who's alleged to be the defendant. Who is Dina Newsom?
Right here.
Okay. All right.
Right here.
Okay, that's Miss.
Yeah, this guy reminds me of Aziz Ansari for sure.
Newsom. Okay.
I'm trying to get with the breakout room.
And Jimmy Rose, we need him to mute. So thank you. So I need Miss Newsom and Miss Johnson to raise their right hand.
Raise your right hand.
You're not. Raise your right hand.
Okay.
No.
I don't know. Well, hold on. I don't know who you are yet.
Okay.
I don't know why I need to even have you there. I can guess, but I will tell you that that's not normally the appropriate thing to do. But I'm going to find out.
Give me 1 second. Don't do that. I can't hear him.
Hold on.
That again.
So Miss just let me get Miss Newsom.
Okay.
And Miss Johnson under oath right now. Okay. Do you swear or affirm to tell the truth under penalty and perjury of the law, Miss Newsom?
He said, do you say to tell the truth, the whole truth, and nothing but the truth?
That's not what I said, but okay.
But she can't hear, so I have to say it in her ear.
I know, but when you don't say what I say, it's not like what I say. It's something else. But I got you. How about you, Miss Johnson?
Yes.
Okay. Let me just do this. Miss Newsom, can you understand what I'm saying? Because you bringing this case.
He said, can you understand what he's saying?
Oh, shit.
I can't hear. I can't hardly hear.
Say it again.
She said she can't hear me.
The judge, I'm putting the phone to your ear so you can hear better.
Miss Newsom, can you hear me?
I can hear you.
Okay. Miss Johnson, you want her evicted?
Yes, I want her evicted.
No, wait. Miss Johnson, let's just pause. You keep over talking me. You're the person who's there trying to get evicted. So let me just start with you since you want to talk. Miss Johnson, tell me, do you own this house that you in right now?
No, but what they...
Wait. Just let me ask you some basic questions.
No, I do not own this house.
You don't own the house. Did you move into the house?
Yes, I moved into the house.
Did you move in with does Miss Newsom live there as well?
Yes, but I want...
I know you want to tell me a bunch of things, and I'm going to give you an opportunity.
Okay.
Right? But I want to know what I want to know first. That'll help. So when did you move in?
I came down here in the beginning of this year. She came and got me from the bus station.
I read your answer, but that's more specific. So what month did you move into the house? Not to Georgia, to the house.
In the middle of the year.
Oh no, what month? You know
I
the
don't
month.
know which month. I currently don't know. I can't.
Summertime, wintertime, fall time?
I was here in the summertime.
The summertime.
Yes.
Before August or after August? Before school started or after school started?
No, when school started, I've been here since day one.
That's not an answer. You been here before school started in late July, or you been here after school?
July, yeah.
Okay. And when you moved in, was there ever an agreement for you to pay any rent?
No, it was no agreement.
How long were you supposed to be there for a particular amount of time?
The agreement was, she said that I can keep my money, but just put food in the house.
Okay. And since that time, have you been keeping food in the house?
Yes, been feeding her, eating my food up. Kenny is nothing.
Okay, hold on. And she now wants you to leave, but you keep saying you want her to leave.
Yes, because she has her name under all my stuff. When I talked to the judge the first time, she told me to look up my credit and see what's everything that's under my name. Like the vehicle that's sitting outside is under my name. My mom put in her name, and they didn't have no consent of using my name.
Okay, well, I'm
He
not
did this
dealing with
behind my back.
those issues. I'm dealing with stuff dealing with the house, right? So they want you out, but you telling me, right, that you want them out. Well, you can't put them out if it's not your house. So Miss Newsom is it Miss Newsom's house?
Is it your house? Do you own this house, Granny? No.
Well, who's talking? I'm asking. Just wait.
What are you saying?
Is it Miss Newsom's house?
It's she rich from Section 8.
Oh,
It's not her house.
I understand that part. But what I'm asking, and I'm needing to ask Miss Newsom. Let me just tell y'all, man. When people bring
Out of my house.
Wait, Ma. Listen to the judge first. Hold on.
Okay. All right. When you want somebody, you gotta know what you're asking for, because I'm gonna have to ask you questions. You just, So let me ask you this, Miss Newsom. Did you send her? I know you're saying you didn't want her to live there, but she's saying she's been there since at least July, late July. Is that the case, Miss Newsom?
Remember she came in July when we was out of town?
That's not what I asked. What are you doing?
When
You
did she
can't
get there?
Yeah.
listen. You know what I really feel comfortable doing? This case was on my calendar in person.
Wait, Ma. Wait, I can't.
Just hold up. This case was on my calendar in November. What happened there? Did you guys come?
Yes, we came, but she was in the hospital.
Okay, I think it's better for y'all to come in person.
See, the thing about coming in person right now is because I work during the day and I have to take off. I'm the person that pays all the bills here.
I got it. But so one, I don't know if your mother and I can reasonably pursue, because there's things I need to ask. This isn't a pure, I haven't paid rent.
Please.
What did you say?
But that's not what's being alleged. It's not being. So there are notices that need to be sent. And if she ain't send her, let me ask you this. You sent her a 60-day letter, Ms. Newsom, before you pursued this action?
He asked, did you send her a 60-day letter? And what the judge had told us that we let her know that she had to leave. And she did that when she first came in. He asking you, did you let her know within 60 days that she had to leave?
No,
I'm sorry.
No, that's not. Let me ask Ms. Johnson.
I didn't.
No, that's not what he asked. There's a statutory provision, apparently, that you have to send a 60-day letter. Not that you just have to mention it or notify them. Nope, you got to send a letter. That's what you got to do. Oh, my God.
They asked her to come either.
Okay.
She just came.
She just came?
Drop her butt over here.
Mm-hmm. And she been there
She was
since
staying with her sister. And stuff didn't work out. She just dropped over here. She just asked me, could she stay?
I want to go in person.
Okay. And so she didn't ask, but you let her stay that whole time?
Tell them about when we called the police and what the police said.
When'd you call?
Grandma just comes in and makes noises. She can't hear, so she doesn't understand anything. And when she speaks, it's unintelligible. I'm sorry, but I don't know what the hell you're supposed to do with that. I really don't.
Call the police.
Daddy, she brought me out in the morning, and I don't say nothing to her. She just talked to me, just brought me out.
Ms. Johnson, you've been mean to your auntie? Is that your grandmother or your auntie?
I want her to get out of my house.
That's her grandmother. And then we do have a police report because they ended up going to the hospital on the day right before then.
What's your name? Is you Miss New? Are you Mr. Newsom as well?
Yes, I am. I'm her daughter.
All right, raise your right hand. Auntie. You swear or affirm to tell the truth under penalty and perjury of the law?
Yes.
All right. So let me just tell you this, okay? So I know you're one. It's not that your mother isn't competent to do this, but if I can't understand what she's saying or she can't understand me, it does make it difficult for us to proceed. Now, the main question I'm going to really have for you guys, and this is really going to determine how we proceed, is did you give your granddaughter, who has been there at least since July, a 60-day notice before you filed this action, which you filed back in October? That means you would have given her notice at least sometime in August. Would you give her a 60-day written notice to leave?
Yes, we also had told her what happened is
she
got a notice.
Listen. I ask simple questions because these cases, a lot of these cases, and I don't like.
I'm sorry.
You got to answer because I'm looking for specific things.
Specific things.
Specific.
Yes.
I'm looking for a letter that you provided to her at least before August 21st that said, I'm giving you, or at least really before August 20th, I'm giving you 60 days to vacate. And if you don't vacate, I'm going to really it needs to be by August 17th. But if you don't vacate, I'm going to file a dispossessory action against you if you're a failure to vacate, right?
Yes. Did you not get that, Destiny?
I want them to.
Destiny, did you not get that?
No, hold on. Wait. Let me wait.
Yes.
I asked you.
Yes, sir.
And now you're trying to pass the buck.
Yes, sir.
That's what I want to say.
I'm sorry.
And they talking over me.
Hold on, Miss Johnson. Miss Johnson, you're not doing any help for yourself, because the moment I got on this thing with you, you've been a little bit over talkative, overly high energy, and it makes me think maybe you do need to go. So just relax and let me ask the questions. You standing back there like it's your house. Just relax.
They use my name, and it's the fact that I'm gonna have to go. I'm gonna have to do a police.
But if you gotta go, then you should go. But if you don't have to go, that's different. But if you want to go, they want you to go. But let me ask you this, so we can make sure I have authority to make you go, if that's the case. When did you, Miss Newsom, mother or even daughter, provide her a written letter, 60 days, indicating that we don't want to rent to you, or you can't rent here anymore, or stay here anymore, because you don't have to pay money to rent someplace, and you got 60 days to go?
It was, let me see, we got back July 17th.
Mm-hmm.
And that's when she got the notice, July 17th, because we were out of town when she came. And my nephew, who was on a lease, he's here too.
Mm-hmm.
He's too. And he let her in. And when we did, me and Destiny was at court the first time. And the judge had said, because he's on a lease, if he had something to say, that he will be able to say it in this court hearing too.
But I don't know what the other judge has to say.
He's 18. He's 18 and he's on a lease.
I'm asking you, when did you give her a 60-day letter?
On the 18th. I want to see either the 18th or the 19th of July.
And you gave her a written letter on the 18th?
Yep.
And what did it say?
Yes, sir. That you have to leave. You have to vacate. We don't want you here.
Okay, and then what did you do?
And then she told me, this is my house. Y'all use my name, and start cussing us out, which we get every day.
She just gave me the vehicle back. I can't talk because she's talking over me. And I want to...
Destiny, how old are you?
I'm 24. That's not right, and I can't talk. She's in the court.
So Destiny, did you get a letter?
No, I did not get no letter. They gave me a letter stating I was getting evicted when that June. She did not give me no 60-day notice.
What did the letter say?
The letter said, can you go give me the letter that's in that face? Because I'm not gonna lie. I'm done, because this is not it. Like, I can't have a chance to talk.
Well, I'm asking you questions. The things that we need to talk about are really whether or not you got a letter. Have you ever paid? You haven't paid any money. You've only provided groceries, which is cool.
Bring me the letter so I can show. I have proof. I'm having my sister.
I just want to know it. Listen, that's what it really comes down to. Unless you told me you've been paying rent and you haven't, they've been accepting rent, and it's different. Then you have more so gratuitous tendency. So
right here,
that can be canceled. You just got to give them 60 days notice.
I got this letter. This is all I got.
What's it say?
It says a eviction from Dina Newsom. Then it says Destiny moved in while I was on vacation. Mind you, why would you sit here and use like have all this stuff has my name on it, and they did this behind my back.
What all this stuff? Are there utilities at the house that have your name on it?
They put their names on the utilities, the gas.
Well, hold on. Just wait. You're saying the utilities for the house have your name on it?
They have their name on it.
Okay.
But they is on my lease.
Hold on, because I want to know what you're saying, but you're not answering me really clearly, right? Are there any utilities for the property that are in your name?
No, there's none in my name. They put it in their name.
Okay, then what are you talking about that's in your name, other than a car that isn't associated with the property?
Say that again.
Other than a car, are there any utilities associated or anything?
They put it in they name. I can't even.
Associated with the property.
Section A. That Section A has my name on it too. But they didn't put my section. They didn't put my name on it. Like they used my name though.
Wait, but so are you not on the Section 8 contract?
They didn't put me on there.
But you're saying they used you by saying that you're a person who resides there. Is that what you're trying to say?
Yes. They use.
Okay. Hold on.
This lady keep. I can't talk while this lady's sitting right here.
Stop. Miss Newsom, when did you sign your Section 8 contract? She's saying you used her as a person who lives there. Did you guys do that?
No, the Section 8 came from Gary, Indiana.
No, that's not what I asked. What are you not hearing?
I'm sorry. I'm trying to be not.
You only want to tell me what you want to tell me. You don't want to answer what I'm asking.
I'm sorry. Say that again, sir.
I'm asking you, did you guys list or at least identify Miss Johnson to be as one of the persons living there to Section 8?
No, sir.
Okay. All right. I know you're answering all these things, but you're not really the person who has the contract. It'd be your mother and your mother.
So for Section 8, I'm sorry, for Section 8, I do have power of attorney. And for Section 8, I'm the one that did her Section 8 for her.
Okay.
I had to go to legal aid in Georgia to get power of attorney for it. And I do have those papers.
When did you guys call the police to get her out? Since she didn't get out when you guys said she gave her that letter.
I'm sorry, say that again.
When did you guys call the police to try to get her out?
The first time was in June. And instead of her going to jail, we had her sent, the police sent her to Emory Hospital, where they did release her. But also at the same time, her twin, because they were getting into it, which we'll be back on here next month, because we're going to do one at a time, that she actually had to stay into the mental ward.
No,
for a week, and then they sent her to another facility.
He don't want to talk to you. He said this like multiple times, but I should have just let her ask to do it in the court instead of Zoom, because I don't know how to do the Zoom.
Listen, folks, I think I'd be
holes in the wall.
Do it in person. I'll be honest with you.
I'm sorry, I can't hear you.
I honestly, I don't think Miss Newsom, if the letter that you gave her was back in July and you filed this in October, but the letter doesn't, it just says, I didn't give you authority to move here, and then you don't do nothing else to get her out, and then she stays there for months. Like, you know.
So this is what happened.
Okay, you don't tell me. Okay.
This is what happened. We were out on vacation. We came back, she came in. Mm-hmm. So at the time, with my mom being on fixed income and me working and I'll pay all the bills, I couldn't afford to come down there and pay it.
All her stuff is still in Indiana.
So when we had the money to afford it, that's when we came. That's why it was so long.
There's so many loans in my name. Ladder said you put your identity.
That's why it took so long. And I just wish Josh would make me be able to pay the bills and have extra money to be able to go ahead and go forth with it.
Mm-hmm.
But once the police officer told her, long as she had mail here.
Well, how long was she there before June? Because she said initially.
Okay, so she ended up leaving in June and going to a boarding house.
No.
Or was wherever she was, she wasn't here. And then she came back in July.
I have proof that she threw all my clothes on the ground, messed up. I cannot
listen. I'm gonna be honest. I don't really think you gave her the 60-day letter.
And we did. Hold on. I do have Patrick, which is on a lease.
No.
That's not what I'm saying. A lease is different. And I get, it's not that I'm frustrated. What I'm saying is I do see that you guys have a real issue, but at the same time, I do see that you guys have not really followed through with your real intent. And
yes, I do. That's what I was saying.
What the law requires. You know what I mean?
I did.
Did you guys at least don't did you send her at least a 3-day demand letter?
Yes, at first they told me I didn't have to do it. I'm not crying. Could you please be quiet so I could talk to the judge?
You always have to do a 3-day demand letter. You never have to not do that.
Right. So when we went and we found it, they asked us that. And what was told and did. And that's why I was saying that I actually have another person.
Did you do a 3-day demand letter?
Did a 3-day demand. What? Written on a piece of paper. I didn't know if I needed to get it notarized. Do I have to have it notarized? No. We are subject to verbal abuse every day.
No, she's lying.
From the time that I get up.
Miss Johnson, it doesn't seem as if that would be not the case. You guys seem to have a little contentious interaction as we speak.
And I also have told her the abuse that she give my mom while I'm at work.
But listen.
It's a felony. It's called.
It is. Now listen, Miss Johnson, I'm gonna tell you something. What you're communicating to the court right now is that you've been very, very kind of, and I know you feel like it's unfair, but you have shown the court that you're not willing to just be quiet and wait. And so it does seem like you may exhibit some of these type of behaviors. But I think the greater concern, though, folks, is that you do have to still give these demands and these notices so people can prepare. You know what I mean? I understand you said you gave her something back in June, but that was a little while ago, and obviously things have seemed to progress. And you didn't give her a demand letter, which at minimum would have been required, even if the 60 days somehow would have been something that wasn't. But you got to give a demand letter. Let her know, hey, look, we got to have you gone. You know what I mean? If you don't go, I'm gonna file this eviction action against you, because these still are legal proceedings, right?
I did that.
Okay. Well, then, if you don't have the things in your possession now, then I will hold, and I will set it in person. I know you don't want to come down, but I will tell you, if you come down and you don't have all your appropriate paperwork, it's going to get dismissed, right? So if the paperwork is there, I'll reset it so I can see it. But if the paperwork ain't there,
I got it.
It might as well be dismissed, and you do it. We're right.
I got it. And I got witnesses.
And if it ain't done right, then you're gonna end up having to wait a long time.
No, I got it.
So I'm gonna reset it, and we'll set it down for an in-person calendar, and we'll see what happens. Maybe you guys can reach a resolution before then, because ultimately you're family, and unless you plan on never dealing with them ever again,
never in my life, and that's my daughter.
Yeah, then I don't think you thinking that one.
She doesn't have the paperwork. I can almost guarantee it. She really should just dismiss it. She should get an attorney. It's literally, I know she doesn't have money, but it's cheaper and faster to this is not expensive stuff. This is volume stuff. And it's real nitpicky. You got to do everything right.
So I'm going to get it reset, and I'm going to let you think it through.
No,
I'll see you guys at another time, okay?
Hold on, I got a question.
Mm-hmm.
I got a question. Do I have to have this paper notarized?
No, the paper would have been given to her prior to this action being filed.
No. I'm saying, did it have to be notarized?
Don't have to be notarized.
Okay, I got it, because they be throwing stuff away, but I got it. I got it put up.
Of course, see everything. They looked up everything. They got copies of everything.
And you said this is your niece in the background?
That's my daughter.
Oh,
you did this behind my back, my own mama, right?
All right. Well, I will. And okay. Well, listen, we'll see you guys when it's reset. All right.
So when can we get a reset date today? Because I have to.
My clerk will email you, and you'll get plenty of notice to.
And then my next question is, because if my mom happens to be in the hospital, what is it that I will need to do to be able to represent her in court?
Well, the only thing I will tell you, because it's not legal advice, it's just the law. You need a designation of agency. You cannot proceed in the name of another party at minimum. And even then, designations of agency are really for businesses. They're not really for private people. But that might suffice. But if you're power of attorney, you might want to supply that as well. So if you're saying the authority to do that, not power of attorney. People get the difference. Not the power of attorney for making people's medical decisions.
No, I have
power of attorney. You understand?
I have full.
Okay, so people submit the medical power of attorney. I'm like, that ain't it.
No, I have full power of attorney, like I said.
We'll look for you to maybe submit that. But especially since I couldn't really get a full communication with your mother, who's the plaintiff, I don't really feel comfortable making a decision either. She couldn't really communicate to me.
I can, like I said, I can put the phone up to her ear. She can hear you.
Listen, it's all good. We're gonna get it right. I'd rather get it right. So I'm gonna reset it, and we'll see you guys back.
Ain't nobody crying. Please be quiet so I can hear the judge.
All right, and you guys are free to go this evening, okay? Please, and please don't have things get out of hand. Again, you can always call the police, but the problem, ideally, we do not want to have the police having to be called, okay? So please.
We're at that point.
It's the holiday.
I tried to wait until court, but we're at that point.
I understand. All right. Well, look, folks, I'll see you guys back in person.
Thank you.
Make the in-person calendar. Thank you.
Yep. Oh, I got power of attorney papers.
Okay. You guys are free to go. Do we have any announcements on anybody else?
No, Judge. They're still in mediation.
No worries.
There you have it. I had not seen 1 second of that. That was fantastic. I mean, it's sad. I know it's sad, but more so than sad, it's freaking hilarious. Oh my God. I can't even imagine this. It really, I'm going to take you out with it because it really puts me in mind of Moat Point. It really does. We'll close it out. We'll close it down for the night with Moat Point.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. Words all twisted. Sherrick Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He realliterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a Moat Point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like it's courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick. But he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose. But every fake word just adds to your blues. Mirandarize this, Moat Point that. Sherrick Vaughn rap dictionary looking flat. It's a Moat Point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Mirandarization, unlogical station, compellment nation, courtroom clown in rotation.